No. Camera not supposed to choose. Such as I'm looking for
Sorry about the audio. It's not me, it's the live stream.
Can you hear me? Hello? Can you hear me? Okay, back in free. Thank you. Take your seat. Good morning. Thank you. Wait. Counsel, please introduce yourself at your time.
Your Honor, my name is Dan Herian, and I represent plaintiff Dave Walker.
Good morning. I'm ready.
Yes, sir. May it please this very honorable court, last night, the court received a letter from Mr. Johnson, attorney for the defendant. The last paragraph I'd like to read into the record states, we await your taking the requested action, and as we do so, we will, of course, suspend further participation in these proceedings, including the hearing scheduled for January 26th. As the court can see, neither the defendant nor the defendant's attorneys are here. The Secretary of State responded with a letter to Mr. Jablonski last night stating that if they don't show up, it will be at their own peril. Your Honor, the plaintiff calls the plaintiff, Mr. David Walker.
Please. Counsel, you have 30 minutes. Can I? Sir, will you stand up and raise your right?
Is there a testimony after this occurred at the hall of the applicant on behalf?
Sir, please state your name for the record.
David Weldon
Where do you live?
in Powder Springs, Georgia, in Cobb County.
Are you registered to vote in the state of Florida?
Yes, I am.
Showing the witness is the mark for identification plaintiff's one. Are you familiar with that document?
Yes.
What is it?
It's the birth certificate that I downloaded from the White House.gov website. It's a birth certificate professed to be of Barack Hussein Obama II.
And you see an item on line 8. I'm sorry, excuse me, on item 11. Can you read that?
Yeah, so the item 11 says the birthplace is Kenya, East Africa.
And I'm referring
That
to
is the birthplace of the father.
move to have exhibit plaintiff mark for identification plaintiff exhibit 1 in the record.
Then one is correct.
That's all I have for this witness.
Thank you, sir.
Only Lieutenant Allen. Oh, I'm sorry, Your Honor, I gave up another item for this witness. I apologize. Referring the witness to what has been marked for identification as exhibit 3. What is that? Are you familiar with this?
Yes, I am.
What is it?
This is pages 214 and 215 of a book authored by Barack Obama entitled Dreams from My Father.
Can you read the highlighted portions?
Yes, portions that I highlighted.
Sorry.
The portions that I highlighted, our first one is on page 214, where I just highlighted a couple lines to indicate the time frame within the book. And this was in 1966 or 67, according to Mr. Obama. The section on page 215, I highlighted with the purpose of illustrating some history of his father. And his father had been having trouble with obtaining employment up to this point. And I'm going to quote here, it says, when he went to foreign companies to look for a post, the companies were warned not to hire him. He began looking abroad and was hired to work for the African Development Bank in Addis Ababa. But before he could join them, the government revoked his passport and he couldn't even leave Kenya.
That's all I have to do. Calling, witness Kenneth Allen. Referring the witness to what has been marked for identification as plaintiff's exhibit 2. And move that exhibit marked for identification as moved in the record. Are you familiar with the document that I presented to you? I am. What is it? Well, it's from Immigration and Naturalization Services, and it actually is about Barack Obama Sr. And it was noticed of his F1 student immigration status. And what is the date at the bottom of the document? June 27, 1962. There's a fourth number at the top of the document. Yeah, it's 1-208, 220D. What's your understanding of the purpose of this document? Well, this document actually helped him get into the University of Harvard.
What does it say about his status as a citizen of the United States?
Well, he's not a citizen of the United States, so his status is that from that.
How did you come to obtain this document?
Through a Freedom of Information Act that I filed in February of 2011.
And is this the copy? Is this copy an accurate copy of the document that you received from the Freedom of Information Act?
It is.
And for the record, I'd like to read Georgia Code section 2414, matters judicially recognized matters. I'm quoting, the laws of the United States and of the several states, customs of merchants, and all similar matters of public knowledge shall be judicially recognized without the introduction of proof. I read that to point out that this document, under not only Georgia statute, judicially recognized but under Georgia precedent, should fall within the business records exception to hearsay exception. That's all I have for this witness, and that's the close of the evidence for Mr. Weldon.
Take that one minute, 20 minutes. And I believe that I can cover it in 20 minutes, Your Honor. As I stated before, our hope here is to help the court understand what our core argument is. What we're trying to show here is that Barack Obama, by the evidence, Barack Obama's father was not a United States citizen at the time of the defendant's birth. And under Article 2 of the United States Constitution, that means that he is not a natural-born citizen, as was defined by the Supreme Court in Minor v. Happersett. In Minor v. Happersett, the court recognized three categories of people: natural-born citizens, and everybody else. Now, the court also noted that all natural-born citizens are citizens, but not all citizens are natural-born citizens. There are three paths to citizenship in the United States, all of them founded within the Constitution. The first one is Article 2, natural-born citizen, as defined by Minor v. Happersett. The second one is naturalized citizens.
which is defined which is defined by Congress as they are authorized to do under Article 1, and then there's the 14th Amendment. Now, it should be noted that all naturalized citizens that are naturalized under Congress's authority under Article 1 cannot be natural-born citizens specifically because Congress does not have the authority to alter the Constitution other than through the amendment process, and therefore all of the statutes and laws, whether or not they purport to define the term natural-born citizen, do not, because they cannot alter Article 1. Now, the 14th Amendment is a separate issue, but it also does not include natural-born citizens for reasons that I'll get to in a moment. In order to get there, we first have to remind ourselves that the rules of construction were set forth by the early Supreme Court in Marbury v. Madison, and have been followed ever since by every court. The rules of construction that are applicable here are, first, under Marbury v. Madison, Chief Justice Marshall stated that no clause in the Constitution can be construed in a way by any court that would leave it without independent meaning. Now, a corollary to this rule, is any future amendments to the Constitution must not be construed in a way that removes independent meaning from another clause unless that amendment specifically states that it's changing the earlier clause, or there's no way to construe that amendment in any other way other than changing the earlier clause. So with that rule of construction in mind, we look at the fact that the minor court defined a natural-born citizen, and that definition was, it was never doubted that all children born in the country of parents who were its citizens become themselves upon their birth citizens also. These were natives or natural-born citizens as distinguished from aliens or foreigners. So there's two elements to this definition. First, both parents have to be citizens at the time that the defendant was born, and the defendant had to have been born in the country. Now, a lot of people say that this is dicta, and that therefore the court doesn't have to follow it. It's persuasive, but it's simply dicta. That is absolutely incorrect. We will prove that beyond any doubt, starting by looking at the definitions of holding, dicta, and precedent. The definition of Black's law of holding is a court's determination of a matter of law pivotal to its decision. Dicta is the opposite. A court's discussion points to questions not raised by the record or its suggestion of rules not applicable in the case of Clark. Now, as precedent, a case becomes precedent only for such a general rule as is necessary to the actual decision reached. What I'm going to show is that the definition for minor was pivotal to the decision of that court, and is therefore holding of that court, and therefore precedent, which is binding, in Supreme Court precedent, binding on every court in this country. The definition was what the minor court had to decide was whether or not Ms. Minor was allowed or had a right to vote in the 14th Amendment. However, it specifically stated that before it got to that part of the question, it first had to determine whether or not she was a citizen. Well, using the well-known doctrine of judicial restraint, the Supreme Court will not will not construe a constitutional clause if it does not have to answer the question presented. And in this case, Minor was born in the United States and had both parents were citizens at the time she was born. So therefore, what the court did was it defined a natural-born citizen, and then specifically said she's a natural-born citizen. Therefore, we don't have to determine whether or not she's a citizen under any other rule. It was pivotal that she was a natural-born citizen. The definition they came to was part of the holding and binding precedent. Now, there's other language in this paragraph that others point to as saying, well, there was doubts about this particular definition, even if it's precedent, because the paragraph goes on to say some authorities go further and include as citizens children born within the jurisdiction without reference to their citizenship of their parents. However, the court should be recognized also that the term citizen is not natural born citizen. And the term citizen was specifically defined by the minor court on the previous page. In fact, they spent at least a couple of paragraphs discussing what a citizen was and describing how it's a very broad term. And at the end of that, they concluded that when they say citizen, they mean nothing more than this broad, nebulous term that they don't need to define and can't define. And in fact, the rest of the paragraph goes on to reflect this judicial restraint that the minor court was using when they say, for the purposes of this case, it is not necessary to solve these questions about the doubt of what a citizen is. It's sufficient for everything we have to now consider that all children born of parents within the jurisdiction are themselves citizens. In other words, Minor is a natural born citizen, therefore she's a citizen, and they moved on to the next question, which was construing not the whole 14th Amendment, but just what rights arise from the 14th Amendment, whether or not she should have the right to vote. And by the way, that court held that the 14th Amendment does not create any new privileges or immunities. Therefore, someone who is not qualified as a natural born citizen to run for president before the 14th Amendment does not have that right, because the 14th Amendment didn't create any new rights. They don't have that right excuse me, after the 14th Amendment. So, that's the holding of Minor. A lot of people say that Minor was overruled by Kim Long-Art. That's absolutely not true. The holding of Kim Long-Art is right up here, and it's very limited. Lots of caveats and lots of conditions, but the point is that the minor court, the Kim Long-Art court was determining what the minor court had left behind. The minor court had said, we're not going to determine what a citizen is under the 14th Amendment, because we don't have to, because she's a natural born citizen. The Kim Long-Art court had that case because they had Kim Long-Art, whose parents weren't citizens when he was born, but he was born here, is he a citizen? They answered that question, and that's all they answered. Everything else that they answered, everything else that's in there, anything that could possibly be construed to change the holding of Minor, the definition of natural born citizen under Minor, was dicta, and is therefore not binding, and certainly under the rules of construction cannot overrule an earlier holding. Dicta certainly cannot overrule holding. So the point here is, these cases don't conflict. They might look like they conflict if you read them, but if you look at the holding of Kim Long-Art and the holding of Minor, they don't conflict. And when they clearly don't conflict, they certainly don't overrule each other. If anyone was to argue that the Minor definition of natural born citizen is unclear as to whether or not it's required to have one parent or both parents, I would like it stated for the record that the Minor court's definition of natural born citizen uses the term parents. Parent is the singular. If the court wanted to use parent, it could have used parent. If the court meant mother, it could have used mother. If it meant father, it could have used father. It could use the term parents, and that has to be given, again, a rule of construction. It's plain meaning. Plain meaning here called parents, so that argument doesn't apply. In closing, this case is about the Constitution. Holding public office is not about the individual. It's about service to the public. Anyone who's running for public office ought to know that. And that means that even if an individual has an unfortunate situation where they can't rise to the level that they want to, politics is not a typical career field where we want the person to rise as far as they can. Politics is about service to the public, and that should be kept in mind. And my final comment, let me make a point for the record. We've shown, I believe, that Barack Obama's father was not a citizen of the United States ever. Certainly during the time period when Barack Obama was born. I don't think that's ever been disputed by the defendant himself. And that means he is not constitutionally qualified to hold office. It's not a statement about his ability, it's a statement about his constitutional qualifications. Finally, the defendant was ordered to be here today. He's not here. His attorneys are even boycotting this hearing. And I want to state it on the record that shows not just a contempt for this court, but a contempt for the judicial branch. And I'm not interested in commentary on that. But you done your argument. Yes, sir. Thank you very much. Thanks. Thank you very much. Counsel, will you please introduce yourself and your
I am counsel for Paul Swenson and Kevin Powell for living, my co-counsel, and my brother Tommy is here with me as well. I wanted to raise two issues before I undertake the attendance. Your Honor, first of all, before we have a motion filed for determination of placing voting proof in this case and Bridges County. The other thing, Your Honor, is on January the 19th, I submitted to opposing counsel Michael Jablonski filing with this court a notice to produce which was directed to President Barack Obama in this case. I know that Mr. Obama is not here today, nor is his counsel here today, and I would note that the court has authority under OCDA 50-13-13B to take appropriate steps to punish any contempt of this court, which results from the failure to appear as to produce the records and documents that have been subpoenaed in this case, and we would commend that to the court. In that connection, I would like to, at this time, tender plaintiff's exhibit number 10, which is a copy of the White House schedule from today, January 26, 2012, which shows no permanent schedule. Judge, I would tender that into the record.
Okay. On March of that's exhibit 10. It's an attendance of the
But I will
Counsel, you have 20 minutes.
Yes, sir. Call Mr. Carl.
You swear to testify you're about to disprove all the truth in the record.
I do.
Will you say your name, please, full name?
Carl Swenson, Carl Alfred Swenson, Jr.
Mr. Swenson, where do you live? What's your address?
6553 Pleasant Valley Drive in Morrow, Georgia.
What county is that?
Clayton.
Mr. Swenson, are you a registered voter in the state of Georgia?
Yes, I am.
And were you a registered voter in the state of Georgia at the time that you submitted the challenge which initiated this case?
Yes, I was.
And are you qualified and able to vote for candidates for president of the United States as president of Georgia?
Yes, I am.
But may approach on it. So you went in pre-mark plaintiff's exhibit number 2, asking if you can identify that compilation set of documents.
Yes, these are, the first one is from the Secretary of State acknowledging that the challenge has been accepted by this court, as is the second page. And the third page is the applicable laws and regulations pertaining to this case. The fourth page is Secretary of State Kim's acknowledgement that they are going to put this, let's see, this is from the Democratic National Chair that notifies the Secretary of State that Obama is going, candidate Obama is going to be on the ballot. And the next page, official challenge, is what I sent to Mr. Kemp, requesting this particular hearing and having him be on notice that I was challenging Obama's being on this ballot.
And the last page that's in that record, is that a photo record that indicates that for you as a voter in the state of Georgia?
Yes, it does.
The challenge that computers within that document, within that set of documents, is that challenge that you filed initiating this case with the Secretary of State's office?
Yes, sir.
Did you file that challenge within the time limit allowed by law for filing the challenge after the qualifying period is the presidential candidate?
Yes, I did.
Your Honor, with that, I would tender plaintiff's exhibit number 2 in that.
Exhibit 2 is correct.
Mr. Swenson, you may say. Kevin Powell.
Yes, I do.
You say your full name, correct?
Kevin Richard Powell,
I will give us your address.
2633 Davenham Lane, Duluth, Georgia, 30096,
What county do you live in?
Gwinnett County.
And are you a registered voter in the state of Georgia?
Yes,
At the time that you initiated the challenge or filed the challenge to initiate this case, were you a registered voter in the state of Georgia?
yes, I was.
And are you able as a registered voter in the state of Georgia to cast a ballot for president of the United States?
Yes, I am.
Well, to show you what's in pre-mark plaintiff's exhibit number 3, I ask you to identify that for me.
This is from Linda Ford to Chief Clerk, the candidate qualifications challenge for Barack Obama, and it has the Georgia code.
Ms. Powell, let me sort that and say for you.
Yes, sir.
Is that composite exhibit a record of the challenge that you filed with the Secretary of State's office, challenging Barack Obama's candidacy in this case, and the related documents that were generated by the Secretary of State's office?
Yes, sir, it is.
Okay. I would tend to plaintiff's exhibit number, is that number 3?
Yes, it
Is
is.
that plaintiff's exhibit number 3? Plaintiff's exhibit number 1, Mr. Powell, is that in fact a letter from Mr. Michael Berlin, the chairman of the Georgia Democratic Party, submitting the name of Barack Obama as the sole Democratic candidate for president in 2012?
Yes, it is.
Move to tender plaintiff's exhibit number 1 today.
Number 1, correct.
Next, show you plaintiff's exhibit number 4. Powell, can you tell us what that is?
This is the divorce records for Stanley Ann Dunham and Barack Obama Sr.
Those were from the state of Hawaii.
Yes, they were.
And that would include the divorce action and a final judgment and decree of divorce between those parties. Is that correct?
Yes.
Those, to your knowledge, are the parents of Barack Obama, who is president of the United States.
Yes, sir.
So tender plaintiff's exhibit number 4. Yeah.
Number 4 is correct.
We want to show you next plaintiff's exhibit number 7. And you can recognize that.
This is the official certification of nomination from the Democratic Party for the 2008 general election that I received from the Secretary of State's office, and it is officially certifying the nomination of Barack Obama.
And that is a certified copy from the
Yes, it is.
So tender plaintiff's exhibit number 7.
Number 7.
Showing you plaintiff's exhibit number 8. If you will identify that for us, please.
This is the official certified copy of the certificate of nomination for the president, but this is for the Republican National Committee, and it's a certified copy from the Secretary of State.
I would tend to Plaintiff's Exhibit number 8 in that. In connection with that exhibit, Mr. Powell, let me just ask you real quickly. Those were the certificates of nomination, Plaintiff's Exhibit 7 and 8, certificates of nomination submitted by the Democrats and the Republicans respectively in 2008. Is there language on the Republican certificate that is not contained in the Democratic certificate that's relevant to this case?
Yes, sir, very much so. The Republican language says that the candidate meets the constitutional requirements for the office of the President of the United States. And the Democratic certificate of nomination says the following were duly nominated as candidates of the state party for president. It does not include the, it does not state that they are qualified according to the Constitution.
So you connect with the Mark Exhibit number 11. You will identify that, please.
This is from a government webpage, and it is the U.S. Citizenship and Immigration Services, and it's an interpretation with regard to the delineation between natural-born citizen, naturalization, and a native citizen. And
is that something that was a printout from a United States government source?
yes, sir, it is. I saw this myself as well.
And that's from the United States Citizenship and Immigration Service?
Yes, sir.
We would tender Plaintiff's Exhibit number 11. And Plaintiff's Exhibit number 12, Mr. Powell. Then would you recognize that?
This is the letter from Obama's attorney, Michael Jablonski, to Brian Kemp with regard to these hearings.
This was the letter that was sent and received yesterday.
Yes, sir. Indicating that they did not want these proceedings to go forward and they did not want to participate.
Tender Plaintiff's Exhibit number 12. 12. Mr. Powell, you can come down. It's called Kenneth Allen. Judge, while he's taking the stand, I would also like to tender a copy of, as Plaintiff's Exhibit number 9, a copy of the Bill of Dreams from my father, which is authored by the defendant, Barack Obama.
I did.
And Judge, that was immediately better.
Yes.
Will you give us a full name, please?
Yes, Kenneth E. Allen.
Mr. Allen, where do you live?
I live in Tucson, Arizona.
Okay. And Mr. Allen, back in February of 2011, did you submit a Freedom of Information Act request to the U.S. Citizenship and Immigration Service?
I did.
Okay. And I'm going to show you what's been marked Plaintiff's Exhibit number 6 for identification. Ask you if you can identify that for me.
I can.
What is that?
That's the disc I received from the Citizenship and Immigration Services with the 181 pages of documents and an introductory letter from, the department.
Okay. Do you have the original response that you received in that original disc with you here today?
I do.
And you would like to retain those originals for use in other proceedings, is that true?
Yes.
Is the Plaintiff's Exhibit number 6 a true and accurate depiction of the response that you received from the United States Citizenship and Immigration Service in response to your February 2011 Freedom of Information Act request?
Yes, I did.
And Mr. Allen, if you will just tell us briefly, what was the substance and the general substance of the documentation that was being requested from the USCIS and that you received back?
Well, the request was for
any documents that related strictly to Barack Obama Sr.
That's the father of the defendant, Barack Obama.
Yes.
Okay.
Stanley and Santoro Obama, which would be his mother, and Lolo Santoro, which would have been his stepmother. But I received this, and it was kind of split. You have Barack Obama Sr., and then some documents on Stanley and then we followed through with Lolo Santoro.
Okay. Based on the response that you received from the Freedom of Information Act request, that is contained in the documentation in place in Exhibit number 6, were you able to determine whether Barack Obama Sr. was ever a citizen of the United States?
Never.
He was
Never a citizen.
All right, I would tender your Honor pleasure Exhibit number 6 in evidence.
Number 6. Right.
Mr. Allen, you may step down. Judge, assuming that my exhibits 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, and 12 have been admitted, you will rest.
Thank you.
Thank you.
This thing is showing quick. I'm not taking it.